Welcome everybody to our IP Lunch Club series. Thank you so much for joining us today. My name is Megan and I'm one of the 6 team members here at the Sandbox Center. For those of you who may not be acquainted with the Sandbox Center, we are located online and downtown Barrie, and we connect people and their ideas to business resources so that they can create a better life through business. So before we kick things off, I would like to provide a land acknowledgement today. Sandbox is proud to acknowledge that we are positioned on the traditional territory of the Anishinaabe people, which include the Odawa, Ojibwe, and Potawatomi nations, collectively known as the Three Fires Confederacy. We also acknowledge the Wendat Nation Huron, who occupied these lands prior to the middle of the 17th century. We're committed to educating ourselves and our community on the importance of honoring the first occupancy of this land while supporting with actionable steps towards reconciliation. So we are super excited to once again be continuing our partnership with IP Osgoode's IP Innovation Clinic, protecting the ideas and creations of artists, inventors, and business owners allows businesses to grow and encourages innovation. For those who may not be acquainted with the IP Innovation Clinic, they are an innovation to market legal clinic staffed by law students and operated in collaboration with York University's Innovation York, Norton Rose Fulbright LLP, and the International Law Research Program at the Center for International Governance Innovation. It serves a clientele that is needs-based and underserviced, such as individuals or startup companies who may not have the resources to hire a lawyer, a patent agent, or any other advisors. Under the guidance and mentorship of the supervising lawyers, Innovation Clinic Fellows provide one-to-one legal information services to inventors, entrepreneurs, and startup companies to assist with the innovation and commercialization processes. The partnership we hold is so incredibly unique to assist with the innovation. The partnership we hold is so incredibly unique to be able to provide the opportunity for students to have hands-on experiences supporting businesses and entrepreneurs. And then similarly for businesses to have access to this expertise is such a win-win. So before I continue on with introducing the IP Innovation Clinic team for today's session, we are super grateful to have Invest Barrie join us for this series as a presenting partner. The team at Invest Barrie are not only an active and committed partner of the Sandbox on the regular, but continue to serve the local region in more ways than one. Barrie is growing and it's diversified and it's a resilient economy with a population expected to increase to 253,000 by 2041. That's amazing. Through various initiatives, Invest Barrie aims to make it easy for businesses of all sizes to connect and be supported. So I would like to introduce Dave Hyde, manager at the Small Business Center of Entrepreneurship at the City of Barrie, to share a few words.
Thank you, Meg. I appreciate that kind introduction. Thank you very much. And just to say welcome, everybody. And certainly we at Invest Barrie are proud to once again sponsor the IP Lunch Club series. Thanks to partners such as the Sandbox Center, who continue to identify gaps in our ecosystem supports, we're able to proactively explore ways to address these gaps and strategically partner on the execution. Intellectual property is one area in which business owners struggle to find appropriate resources and training. So through the IP Innovation Clinic, businesses can access one-to-one legal information to assist with their innovative and commercialization processes. This aligns with our goal at Invest Barrie to develop a robust entrepreneurial and small business ecosystem while building a stronger workforce for both the Barrie business and student communities. We're excited for this partnership between industry and academic researchers and hope you leave this series with an increased knowledge on all things intellectual property. So thanks, Meg. I'll flip it back to you.
Perfect. Awesome. Thanks so much, Dave. And thank you again to Invest Barrie for sponsoring this series.
Our great pleasure.
Yeah, so today in part 1 of 3 of the IP Lunch Club, the team at IP Osgoode will be outlining how to commercialize your intellectual property. The key aspects of commercialization stem from properly managing your intellectual property portfolio. With a properly managed portfolio, you can monetize your IP in several ways and reduce potential competitors from encroaching on your business. If you have any questions throughout the session, please feel free to use the Q&A function or through the chat, and we will make sure to address them at the end. So without further ado, I will pass it over to Ashley on the IP Osgoode team to get us started.
Awesome. Thank you so much, Megan. Well, we first want to extend a thank you to you and your team for hosting us. I think this is our 4th year strong in the IP Innovation Clinic and Sandbox partnership. We love working with you every year, and we hope to continue doing this for the foreseeable future. I also want to quickly thank Dave and the team at Invest Barrie for their support in bringing the IP Lunch Club to all of you as well. So my name is Ashley Moniz. I am the Assistant Director of the IP Innovation Clinic and also an adjunct professor at Osgoode Hall Law School. So the IP Innovation Clinic's main goal is to empower creative and innovative minds to capitalize on their ideas and build their businesses using their IP. So some of the work that we perform at the clinic can include prior art or trademark searches, IP commercialization and strategy consultations, or even license review and drafting as well. This is the first of 3 sessions that we'll be hosting with the Sandbox Center throughout the rest of March. If you're interested in learning more about IP issues facing artists, writers, and designers, or about incorporating IP strategy into your business, we encourage you to register for our upcoming sessions on the Sandbox Center website. Today, we hope that this session will help you to achieve your business and commercialization goals. And if at any time today or during or after one of our other sessions, you're interested in engaging with the clinic for assistance with any of your projects, you are more than welcome to find the link to our intake form on our website or to contact myself or the IP Innovation Clinic directly, and we will guide you through the intake process. Today's presentation, as Megan mentioned, is about empowering entrepreneurs through IP commercialization. So our fellows today will discuss how to leverage your creations and proprietary information into a profit. And as Megan said, if you have any questions about what our fellows are discussing today, please use the Q&A function below at any time throughout the seminar. And we'll also have some time at the end where you can ask more questions. So without further ado, I am very happy to pass the mic over to our clinic fellows today, Phoebe Liu and Adam Meadows.
Hello, my name is Phoebe, and I'm currently a 2nd-year law student at Osgoode Hall Law School. I'm also a clinic fellow at the Osgoode IP Innovation Clinic. And my teammate Adam is a 3rd-year law student, and he's also a clinic fellow at the IP Innovation Clinic. So the topic of our presentation today is empowering entrepreneurs, effective strategies of IP commercialization and success. So as entrepreneurs, it's oftentimes that you will focus more on the business and product development. But as innovators, you might have heard of intellectual property. But what actually is IP? How can you incorporate IP into your business and your innovation? So with all these questions, today we are here to deliver our presentation to describe different forms of IP that are common to entrepreneurs, and we'll also discuss different strategies that you can utilize your IP such that you can commercialize and get the value of your IP. So to start with today's presentation, I will first talk about why do we need an IP strategy in a commercial setting, followed by talking about what types of products can be protected by IP. Later, my teammate Adam will talk about different methods in which entrepreneurs or companies can commercialize these IP. These include portfolio management, monetization, licensing, and collaboration, IP enforcement, and market share. And at the end, if we have time in the Q&A session, we also prepare a simple case study that the audience can also brainstorm and suggest potential IP strategies based on the methods we have talked about. So first, why is it important to develop an IP strategy? So IP alone is actually different from an IP strategy. IP is to protect the value of the intangibles, including filing patent or trademark application to the Patent and Trademark Office. In Canada, it is known as the Canadian Intellectual Property Office, which is called as CIPO, C-I-P-O. And in the United States, it is known as the United States Patent and Trademark Office, USPTO. There are also different national IP offices throughout the world, but once you file, your product is now protected. But IP strategy is a broader concept and goes beyond just IP filing and protection. The first thing that you might think of is after your application has been approved, you have to continuously monitor the market by enforcing your IP rights on your competitors. And IP enforcement is one of the important IP strategy that Adam will talk about later. And IP strategy is actually a strategy that requires planning at the very beginning from the innovation stage. It requires building metrics and also an evaluation system to assess the value of the product. When you're planning an IP strategy, you have to look at your business and project objectives to identify opportunities and risks to leverage IP to protect investment. For example, at the founding stage, it is always good to brainstorm your IP and technology and seed IP culture and strategy. And during your product stage, you have to create your IP landscaping, for example, how to expand your IP and grow IP culture. And identifying risk and prioritization is a very important concept in IP strategy. IP registration is always a lengthy and expensive process. For example, you have to look for lawyers to draft the claims and specification and define the scope of your exclusive rights. Sometimes filing fee, maintenance fee, filing in Canada can cost around $400. In the US, it might be like more than $2,000, and in Europe, it might be more than $5,000. You don't want to spend so much money that really don't matter so much, and it's impossible to patent or trademark everything. So that's why it is very important to have prioritization when you're developing your IP strategy. And the final goal of IP strategy is how to extract more values from IP from a marketing value. That is monetization. Like how to increase the competitiveness of a company's product and generate revenue. Sometimes you can also communicate your IP value when pitching for support. You can also expand your IP by communicating your IP value to potential partners. So these are all the importance of developing an IP strategy. So this slide will include some forms of common IP that can be used for commercialization. The first thing that you might have heard of is patent. So a patent is actually a negative right in that it gives the patent owner the right to exclude others from making, using, or selling anything falling within the scope of the claimed invention. So you might wonder what is actually an invention. So actually the Section 2 of Canadian Patent Act provides that an invention means any new and useful art, process, machine, manufacture, or composition of matter, or any new and useful improvement in any art, process, machine, manufacture, or of composition of matter. SIPO will only register an innovation if it is novel, meaning that like it is like haven't been disclosed to the public in Canada or elsewhere, but like it will give you a 12-month grace period that allows you to file your design, allows you to file your invention with SIPO, and like that will allow you like a 12-month like public grace period. So the second element of a patent is ingenuity. So it has to have an inventive step involved. And utility means the third element of a patent is like utility. It has an industrial application. But to obtain a patent, it is necessary to first file a patent application that will be examined by a national or regional patent office. In Canada, it will be SIPO. Patent application must be filed or registered in each country where the patent protection is desired. The patent term will be governed by the national law, which for most countries is 20 years, including Canada. It's also 20 years calculated from the filing date. A patent can be sold or licensed to others. So this is one of the very important IP for commercialization. For many technologies, you can also, patents also represent a valuable asset that can also be used to leverage and secure funding for a company. The second really common IP is trademark, which protects recognizable sign, design, or expression that identifies products or service that distinguish them from others. It can be a logo, it can be a company name, or a distinguishable color. And for example, like a Tiffany blue color, UPS brown color, but most oftentimes it's the company name or logo. And if you want to trademark a certain name or logo, you also have to identify the types of goods and services that you will be using your mark in. One popular international classification is the NICE system, NICE. So if you're interested, you can also go to the website on the World Intellectual Property Office or the CIPO, like Canadian IP Office, to take a look at the different definitions of the different classes. And the trademark rights in Canada can be obtained in two ways, either through a formal registration in CIPO, or you can also have through use of a mark in Canada over time. That is the common law trademark. But like the registration provides like a proof of trademark ownership and a presumption of validity until proven otherwise. So it provides a nationwide protection. But for unregistered trademark, well, it receives protection only if certain conditions are met. And enforcing unregistered trademark rights is also a very complicated exercise because you have to gather the required supporting documentation, like to prove that like maybe your trademark has been infringed, but like if it is an unregistered trademark. So copyright is the third common, is also a really common IP. So the Copyright Act provides copyright owners the exclusive legal right to produce, reproduce, sell or license, or publish or perform an original work or a substantial part of it. So original means like one of the Supreme Court of Canada case defines an original work as a product of the creator's skill and judgment that must not be so trivial that it could be characterized as a purely mechanical exercise. So it provides protection of original literary, artistic, dramatic, or musical works. And one of the very hot topic recently is actually like some of the people might have used artificial intelligence, but how actually copyright of artificial intelligence can be categorized, this is still under debate, and it is a very good discussion to have in the future. So one another thing is industrial design. So it's about how something looks. It protects a product unique appearance, because industrial design can be like found in many everyday products. For example, your phone, like for example, the new iPhone, like there's like a camera island in a new iPhone. It might be categorized as one of the industrial design as well. So usually in Canada, the exclusive right can last for up to 15 years, and it can be registered as well. And actually, industrial design is also very important because oftentimes a function and an appearance of a product comes together when you are selling a product to consumers. So actually, CIPO has conducted a study on the economic impact of industrial design in 2017 and actually found that firms holding industrial design registration have 16% greater revenue per employee compared to firms without an industrial design registration. So some other things is like trade secret, which is confidential information which will be sold or licensed. One of the very famous trade secret is like the Coca-Cola formula, which will be easy to understand what a trade secret is. Contrary to our patents, trade secrets are actually protected without registration. So, but it's also protected for an unlimited period of time unless it is discovered or legally acquired by others and disclosed to the public. So this is often the reason, like there's also some reasons like some people might offer trade secret rather than applying for different the like patent, trademark, or like the traditional forms of IP, but there are a lot of reasons to consider as well. There are also know-how, which is like the professional skills to use, or expertise that is generally confidential. And data is also very important nowadays, which can be known as data privacy and concerns with the usage of the data. So these are really common forms of IP for commercialization. So now I will pass on to Adam, who will talk more about the different strategies in IP commercialization.
Oh, Adam, I think you're muted there.
Oh, sorry about that.
No worries.
Yeah, so thanks, Phoebe. I will begin by talking about the goals of portfolio management, just give you a little overview right now. So obviously, one of the main things that we'll be talking about in this presentation is monetization and how to monetize your IP. So that's one of the main goals. And then also to reduce costs, and this idea of freedom to operate. And essentially, this is like a strategic way of using patents and IP in order to reduce your competitor's ability to compete with you in the field, like similar sort of inventions, using IP to create sort of like a barrier around yourself in the field. And I will just get into that in a second, but I won't go too much into detail because Phoebe described a lot of the different kinds of IP, but obviously with your portfolio, there's a few different kinds of IP. So copyrights, trademarks, patents as well for different things that Phoebe just mentioned. And this image to the right here is actually an image that was the result or caused a pretty large lawsuit. And it's an image of David Bowie from one of his albums that was actually used at a Hard Rock Cafe. And I believe it was in 2017 without the permission of the owner of the image. And it resulted in a very large lawsuit. So it just goes to show how, even like all of these things can be, intellectual property, they can be protected if you do it properly. And yeah, so we'll go back into that concept of the freedom to operate. And essentially what it is you want to gain a competitive advantage in your field to your competitors. So you might have, there's the example of Pfizer and Moderna, obviously. They were both working towards a vaccine during the pandemic. And in normal situations, the pandemic was obviously a very unique time. So Moderna had a patent on their mRNA technology when designing their vaccine. And as you know, Pfizer also used mRNA technology, which would have normally violated the patent of Moderna. But in 2020, when the world was consumed by the pandemic and we needed to find a vaccine, Moderna actually said that we would not take up any litigation against competitors to use our mRNA vaccine technology. But in 2022, they said that they're going to start doing so. So in normal situations, Moderna would have likely done lots of litigation against Pfizer, and then which would have potentially open up the opportunity for licensing, which I will get into in a few slides. But essentially, Moderna had this technology and it would have prevented Pfizer from coming up with that vaccine. So it would have kind of taken them out of that competitive pool. But since they're using it now, they can either litigate them or they can create what's known as a licensing agreement where Moderna is now entitled to a specific amount of royalties from the sales of Pfizer's vaccine. So that is one example of using your patents to increase your ability to operate and decreasing your competitor's ability to operate. So next we'll kind of get into patent monetization strategies, which I were alluded to before in the presentation. I just mentioned licensing. There's collaborative agreements, IP enforcement. So using your patent, if someone has illegally used your patent, you can either litigate them or engage in licensing agreements, or patent sale, which kind of explains itself, but I'll get into each of these in the subsequent slides. So licensing and licensing agreements. So this is generally the most popular method to monetize your IP. And essentially what it is to grant permission to others in exchange for royalties for using your IP. And so, the example of the vaccine that I mentioned earlier is basically Pfizer would now, if they entered into a licensing agreement with Moderna, they would have to pay a certain amount to Moderna for each sale of their vaccine. For a smaller business owner or smaller inventor, it has other advantages too, because obviously Moderna and Pfizer are these very large companies which don't really have issues with advertising and things like that. But for a small inventor, using licensing can actually help you to gain more exposure worldwide of your IP. So if someone wanted to use your IP, say in the US or something, and it was patented, that company could reach out to you to get into a licensing agreement. And now they've essentially given you more exposure in another country. So it provides a lot of advantages to monetizing your IP by entering into these licensing agreements. And then other monetization examples include collaboration. And obviously that's a pretty general term, but there's a few examples here. One being patent pooling. So as the name suggests, using multiple patents from different inventors to sort of collaborate and control the market in that particular invention. So I guess I keep going back to this vaccine example, but say, for example, one company made a vaccine, they have this particular technology that works, it functions, but maybe it's only 80% effective. And this other company has a vaccine that's also maybe 60% effective, but they have this other sort of solution that could increase the efficacy of the other vaccine's effectiveness. So if those companies decided to pool their patents, they each had the patent for the one solution and the other, and combined it, and they got, say, a really effective vaccine, that would be an example of a collaborative effort of patent pooling. And then you can also obviously engage in contracts to collaborate. So working with other companies, using their patents as well. And as well as with IP ownership. So obviously an inventor might want to be the sole owner of their IP, but perhaps collaborating with another scientist or another inventor or something to make a joint IP could result in better product, better exposure in the future. And that brings me to another form of patent or IP monetization, and that is IP enforcement. So this, as the name suggests, is you enforcing the use of your IP that has been misused or illegally used without your permission. So someone is, for example, using your IP or idea without the proper permission, and they're in violation of the patent that you have. So this can result in a few different things that could potentially monetize your IP. Obviously, if someone's illegally using your IP, you would serve them with a cease and desist letter. So stop using it, Otherwise, we're going to potentially sue you. And maybe for some big companies like Pfizer and Moderna, the litigation route is feasible for them, and that's a way that they can get money out of their IP. But for a smaller inventor, this could prove very costly, and it might not be the best route. So it could result in, potential litigation, but the willingness to negotiate for a potential licensing agreement. So companies might not want to get into litigation with you, but they might offer, okay, we will continue to use your IP, but we'll pay you a certain percentage of our sales. And that is just another example of like enforcing your IP in order to enter into a licensing agreement, which further monetizes that IP. And then another example of monetization of your IP is patent sale or selling of your invention. And you might ask, you put all this time and effort into creating this product, this invention, it's your baby, and why would you want to sell it? And there could be a few reasons for it. One, you may not be able to continue it for financial reasons. Two, you may not be interested. You might not be a business person. You might be a scientist, for example, and you just are interested in creating this particular invention and going on to another invention. And it also might not be feasible, or you might think that another company could potentially bring this product to market better than you and actually help potentially save lives, whatever the invention may be. So in this case, with patent sale, in order to do it properly, you have to consider several things in order to get fair market value. You have to see how applicable the product is in the market, and you have to evaluate the market value of the patent itself, see how many potential buyers you have, and this patent's potential for monetization in the future, which would result in negotiation and eventually selling your product for a price that you deem fit. And then, it might let you go on to pursue new inventions and then maybe sell it in the future as well. And lastly, this brings me to the last part of the monetization strategies, and that is known as market share. And market share is essentially another form of collaboration, which I'll give an example of it is, say, for example, you've got Apple, who is, a leader in the smartphone space with Samsung. And together they would own the majority of the market in the smartphone field. So they could use each other's IP or collaborate. Obviously, this would never happen because they're competitors. But just to give an example, that having these two large IPs and different forms of protections would essentially eliminate all other competitors from this market, which would result in the market share in that field. And so that's just kind of another example of a collaborative way to monetize your IP. And with that, I'll pass it back to Phoebe. I'm not sure if we have enough time to do this case study, but.
Yeah, I mean, like if anyone has questions, like you can ask us, or if not, like we can just do a case study that that is just utilizing some of the concepts that we have mentioned just now.
I feel like we could definitely go into the case study. There are, we could do a couple questions at the end, but I feel like the case study would be super valuable to go through.
Sure.
Sure.
So the prompt is, a biotech startup has developed a new medical device, and one of the components within the device was created by University Y. So the operation of the device is also run by a software program that was developed by the startup. And the startup manufactured this device for sale. So what types of IP commercialization strategies that can the startup or the university can utilize? It can be something that the companies can register the IP, or what kind of strategies, like the commercializing strategies that they can utilize. I guess if you know if you have some ideas, like you can raise your hand in the Zoom function.
Not seeing any raised hands, unfortunately.
It's okay. I guess I can give, like we can give
Yeah,
like the answer.
perfect. That's awesome.
So like the next slide of the PowerPoint suggests that the startup can do a patent for the medical device because it can be monetized according to Adam's suggestion just now. They can also trademark the name of the startup company's name, and also if the device has a name, they can also trademark the name, like to prevent people from using that name that might cause infringement. And because there's a software program, it might consider a copyright as well. And the manufacturing process, I mean, it can be patent, but it can also be a trade secret, because you can keep it as something that is really a secret in the company, so no one can copy that formula. And the medical device can also has an industrial design registration as well, because it often comes with the function and also the value of the product, and also the know-how of the professional skills that is utilized to develop the medical device. So the university can also do a patent on the medical device component as well, and maybe license that component to the startup for using that component. So this is some licensing agreement that the university and the startup can do. And also they can also collaborate to develop the component or the device as well. And there's also some tips for successful transaction between like collaboration or licensing, because you often for a successful transaction, it's often very good that you identify the IP owner and confirm the ownership and validity. Sometimes you might want to do some due diligence to make sure that the opposite party has actually that kind of IP registration. So you can do a patent or trademark search. And if it is a licensing agreement, determine the rights to be granted, like what, where, like what rights, like who should the right to be granted, is the right a non-exclusive or the exclusive one, what location can the licensee use that right. So these are very important terms to be included in your contract or licensing agreement as well. And if you're collaborating, like if the university or the startup wants to collaborate, so what kind of IP ownership should they distribute as well? For example, if there's a new invention, will it be only owned exclusively by one party or jointly owned? Or so these are something that is really important for parties who want to enter these kind of licensing or collaboration agreements to consider. Yeah, so I think we're good for questions.
Perfect. Awesome. So we do have a time for a couple of questions here. So let me just grab them. So our first question is around trademarks and social media. How do you protect your branding via trademark in Canada when others can create social media accounts similar and in other countries? Is trademarking even worth it anymore?
Yeah, that's a great question. It's pretty interesting because I guess I guess in terms of, it's always like a jurisdiction issue with trademarks. I mean, I would still say trademarking is worth it, but obviously when you're trademarking, it only applies to the certain jurisdiction that you are trademarking in. But there are, examples of international trademarks under the World WIPO, World International Intellectual Property Organization. I believe it's called the Madrid Protocol, where it gives you an international trademark that's functional in over 100 different countries.
Cool.
So I guess it's just, trademarking, and depending on where this social media company is using your trademark is where you run into problems.
Cool. Awesome. And our next question here is, what are some pros and cons of selling versus licensing your IP?
I can take that question.
Yeah.
So it all really just depends on what you want to do with your IP, I guess. Selling, obviously, you get the final sale, but you're no longer involved with that IP. You're selling the rights for someone else to use it, and you are no longer the owner of that IP. With licensing, you still own the rights to that, and you can still potentially develop and be involved with it. So it really just depends on how much, what your future goal is for your IP portfolio. If you want to continue developing this, or if you want to continue developing your business, versus if you just invented something and then you want to sell it off and do other things.
Cool. Awesome. We have time for one more quick one, and that will be, what kind of challenges could I anticipate when negotiating a licensing or collaboration agreement?
I can take this.
Yeah.
I guess it also involves some of the considerations that I mentioned just now, because it's often times like the IP ownership that might be under negotiation. So as I mentioned, identifying the IP owner and confirm the ownership is the first thing that both parties should do. And if, as I mentioned, if it's a licensing agreement, there might be you have to determine who the rights to be granted. Make sure that all the terms have been properly determined and use precise language. Don't use fake language, because it will oftentimes create a lot of troubles when there's a dispute. So as I mentioned, the parties, what kind of right, where is the location that the right will going to be used, and when, for how long, is it permanent, or is it going to be just for a certain period of time, and how? So I think all these are very important things to be determined when you're negotiating a licensing agreement. So as a collaboration agreement as well, you have to elaborate profit fees or royalty structure, use appropriate representations and warranties to distribute the risk, and plan ahead for any dispute or troubles. So these are very important for a negotiation as well. And if you're collaborating, definitely identify who is the IP owner if there's a new invention. Is it both parties, or is it one party have a more IP right, or is it only one party has the sole IP right of that new invention? So these are very important things to negotiate during a contract negotiation.
Cool. Awesome. Sounds good. We had one more question come in, but I just see that he jumped off the call, so maybe we can follow up with him after that. But that is awesome. Thank you guys so much for this insight today. I hope everybody was able to take away some insights that can be applied to your business. A huge thank you again to Dave and Invest Barrie for joining us today and be the presenting partner of this series. We encourage you to join us next week at the same time for part 2 of the IP Lunch Club, Overcoming Intellectual Property Issues Facing Artists, Writers, and Designers, where we'll be talking about legal information as it relates to Canadian copyright law. This could include aspects of your work that can and cannot be protected and how this protection is activated. So I've just put the link into the chat where you can register for that. And I'll hand it over to Ashley for any closing remarks and we'll wrap it up.
Yeah, thank you so much for joining us today. Thank you to Adam and Phoebe. You did a great job. Thank you, Megan, for hosting us today. And we hope to see you all again for the next 2 sessions of the IP Lunch Club.
Awesome. Thanks, everybody.